Hello friends, welcome to Abhinav Goswami Law classes. So friends, in this video we are going to discuss section 40, section 41, 42, 43 and 44. These five sections that I am going to cover today, these five sections fall within the heading of when does judgment of the court of law become relevant. So friends, as far as section 40 is concerned, it is a very important section because it is an extension of the rule of res judicata. So what is meant by res judicata? Res judicata, as per section 11 of CPC, provides that if a particular dispute between the same parties has already been decided, the cognizance of the same cannot be taken by the court of law in future. This is what res judicata is in simple words. So section 40 is saying that if there is any judgment, if there is an order, or if there is any decree which exists, which because of the parties which were there in that judgment, because of the issues that were decided in that judgment, order or decree, prohibits the future court from taking cognizance of a particular case, then that judgment, order or decree can be produced before the court of law to show that this issue has already been decided between the same parties. So what is the relevance of section 40 is, friends? When you read section 40, you come to know that it says the existence of any judgment, order, decree which by law prevents any court from taking cognizance of a suit or holding a trial is a relevant fact when the question is whether such court ought to take cognizance of such suit or to hold such trial. So if the issue before a court of law is whether he should take cognizance of a particular case or not, and one of the parties before the court is saying that this issue has already been decided, so it is for that party to bring that judgment, order or decree of the case which was in which that issue was previously decided between the same parties. And if he does so, then this court is prohibited from holding any trial and taking cognizance of any suit. So it is this section 40 is equally applicable to both civil nature of suits and criminal nature of trials. Okay, so these terms judgment, on order and decree are quite comprehensive, and it include all kind of adjudication that are there by the court of law. So if there is an issue that has already been decided, you can bring any of these three before the court of law, which will prohibit the court to take cognizance of that matter. This is the first case when the previous judgment of a case becomes relevant before the court of law. This is the first circumstance. Now we will move to the second circumstance that is provided by, friends, section 41. Section 41 says relevancy of certain judgments in probate extrajudicial. A final judgment, order, decree of a competent court in the exercise of probate, matrimonial, admiralty or insolvency jurisdiction, which confers upon, this is important, friends, which confers upon or takes away from any person any legal character, or which declares any person to be entitled to any such character or to be entitled to any specific thing, not as against any specified person. This is very important, but absolutely is relevant when the existence of any such legal character or the title of any such person to any such thing is relevant. So friends, as far as this section 41 is concerned, the first thing that you must understand about this, it is only applicable in cases of probate, in cases of matrimonial disputes, in cases of admiralty cases, and in cases of insolvency jurisdiction. So what is so special about these four category of cases? In all these four category of cases, you are declaring someone to be of a particular character, or you are taking particular character from someone. So probate is on the basis of will. So in the probate proceeding, you are what you are doing? You are declaring someone entitled to a certain thing, certain property according to the will. In matrimonial disputes, what you are doing? You are declaring someone to be husband, wife, children, right? Same goes with admiralty. Admiralty jurisdiction means war crimes. So in this jurisdiction, the court is declaring someone to be a war criminal. So a character is being imputed. And finally, in insolvency jurisdiction also, you are declaring someone to be solvent or insolvent. So again, imputation of character. So in these four categories of jurisdiction, all these four categories of jurisdiction, there is an imputation of character. And in cases of probate, and in cases of matrimonial disputes, and in cases of insolvency jurisdiction, there are also cases of entitlement of property also. But what is so special about this? The special thing about these four kind of jurisdiction is that the character that is being vested to a particular person by way of these jurisdictions, or a particular property that is being given to a particular person by way of this jurisdiction, that is against the entire world, against the entire world, not against a particular party. This is very important. So friends, you need to make a distinction in your mind that when two people are fighting for a certain property and it is decided in favor of one person and against another, so this is an issue that has been decided between two parties. So these obligations and rights are personal in nature against one another. But this does not bar any independent person to challenge the authority of this person to hold it, right? But when we come to probate jurisdiction, matrimonial jurisdiction, admiralty jurisdiction, or insolvency jurisdiction, these jurisdiction, what they declare, it is healthy against the entire world. No one can challenge it. It is absolute for everyone. This is the essential difference. So that is the reason that section 41 provides that if a judgment, order, or decree is granting a particular character or a particular property, or taking away a particular character or taking away a particular property in probate, matrimonial, admiralty, or insolvency jurisdiction, then this judgment, order, or decree is relevant whenever in future the existence of any such legal character or title of person is in dispute. So in future, whenever any person wants to challenge this character or challenge the entitlement to this property, this person is only required to bring that judgment in probate proceeding, patrimonial proceeding, admiralty proceeding, or insolvency proceeding, and show, and that judgment will be a relevant fact and admissible in the court of law. But this is not the same case with another case, another category of proceeding. For example, contract proceeding, okay, or property dispute between two parties. That judgment will not be relevant against third party because their basis of challenging it may be different. So that judgment which was decided between two parties, that will not relevant against a third person. But these judgments of probate, matrimonial, admiralty, and insolvency, they are good against the entire world. That is why the judgments in these cases can be brought against to prove your character and entitlement to any particular property. Now come to the second part. Such judgment, order, or decree is conclusive proof. This is very important. We already discussed what is meant by conclusive proof. Conclusive proof is such a fact against which the court of law will not allow any evidence. Even if there is a particular evidence, the court will not allow it. This is called conclusive proof. If this is what you are showing, that means that you are the owner of it. That means that you have this character. No evidence against this is allowed. Okay. Now come to further part, that any legal character which it confers accrued at the time when such judgment, order, decree came into operation. Okay. So what are the things, what are the conclusive proofs that are coming out? The first conclusive proof that is coming out is that when this decree, order, or judgment was granted, a particular character, legal character, was vested in that person at the time when decree was granted. What is the second conclusive proof? That any legal character to which it declares any person to be entitled accrued to that person at the time when such judgment, order, or decree declares it to have accrued to the person. It may happen that this judgment, order, or decree may be mentioning a different date for vesting of this character. It may be a previous date of the judgment. Okay, for retrospective operation, judgment may be having a retrospective operation, or it may be a future date. It may not be the date of the judgment. It may be a different date. So if there is a date mentioned, then that legal character, entitlement of property will be a conclusive proof. That judgment will be a conclusive proof from that day onwards. Okay, what is the third conclusive proof? That any legal character which it takes away from any such person ceased at the time from which such judgment, order, or decree declared that it has ceased to or should cease. The same, this is the first two presumption was about vesting of a character. The third presumption is about taking away of a character. So in any probate proceeding, matrimonial proceeding, or insolvency proceeding, if a particular character was taken away from someone, for example, if an insolvent person was declared solvent, so that character of insolvency was taken away. So that will be effective from the date that is mentioned, conclusive from the date that was mentioned in the decree. And finally, that thing to which it declares any person to be so entitled was the property of that person at the time from which such judgment, order, or decree declares that it had been or should have been his property. So initial three presumption that we have already covered were talking about the character, and this final presumption, conclusive proof, is talking of vesting of property, because it deals with both character and property. It is saying that the property, if it is this judgment in matrimonial proceeding, probate proceeding, okay, or in insolvency proceeding, if it is declaring someone entitled to any property, that will be conclusive proof from the date which is mentioned in the decree itself. Okay, friends. So as far as section 41 is concerned, you need always remember that it is applicable to probate, matrimonial, admiralty, and insolvency jurisdictions only, for the reason that it is good against the entire world. Now come to section 42. Section 42, friends, section 42 is also important uh, because it provides for situations which are left out of section 41. Section 42, friends, provides the relevancy and effect of judgments, orders, or decrees other than those mentioned in section 41. So other than probate proceeding, other than matrimonial proceeding, other than insolvency proceeding, when will a judgment become relevant? Okay, so section 42 reads, judgments, orders, or decrees other than those mentioned in section 41 are relevant if they relate to matters of a public nature relevant to inquiry. So if a particular judgment, if there is a particular judgment and you want to make it relevant, you must ensure, and which is not falling within the category of provided under section 41, then you must ensure that the judgment was relating to a matter which was of a public nature, which is relevant to the inquiry. So friends, as when we were discussing section 41, I told you that what is so special about these four kind of jurisdiction. The speciality was that they were of public nature. The declarations were good against the entire world. They were of public nature. They were not of private nature. So section 42 is providing that if there is any other judgment, any other kind of judgment, order, or decree which is not covered under section 41 but still is of a public nature, good against the entire world, then such judgment or order, decree can be brought on record. But one thing you must understand is that in section 41, that decree in probate, matrimonial proceeding, there those decrees were and orders and judgments were becoming conclusive proof. But that is not the case with section 42. You may bring that judgment which is dealing with a matter of public nature relevant to the inquiry, but that judgment, decree, or order will not amount to a conclusive proof, which means that the court may allow contrary evidence from the other party against that judgment. Okay, so that the judgment, order, or decree cannot be the sole basis of deciding a case. Now look at the illustration. Illustration: A sues B for trespass on his land. A is suing B for trespass on his land. B alleges the existence of a public right of way over the land, which A denies. Okay, the existence of a decree in favor of the defendant in a suit by A against C for a trespass on the same land in which C alleged the existence of the same right of way is relevant, but it is not conclusive proof that the right of way exists. Very, very important illustration and very nice illustration. So what is happening in this case, friends? There are two parties. Okay, A and B. A is suing B. What is A is saying that you have trespassed on my land. To which the B says, no, I'm not trespassing. I have a public right to way over this land. That's why I am walking over your land, because I have right. So how will you prove that? Just suppose there was a previous decree. The same issue has already arisen in a previous decree between, not between A and B, but between A and C. Between A and C, the third person. In that decree, if it was held that C had a public right over that land. So even though the issue was similar, but the parties were different, and that declaration in favor of C, that he had a right to way, was not applicable to the entire world. When it was held that that A against A, that C had a right to way over his land, it did not go for the entire world. It is only a personal benefit for C, right? So that judgment cannot amount to a conclusive proof, but as the judgment is of a public nature, why it is of a public nature? Because if one person has a right to weigh over it, what was the basis of it? On the basis of that, other person may also having a right of way over that land. That is the reason that it is of a public nature, but it will not be a conclusive proof, and it will be open for A to show that what is the difference between the case with C and in the case with B. Okay, it is quite complicated, but as far as section 42 is concerned, what you need to remember is that it is dealing with those judgments and orders and decrees which are of a public nature, which is relevant to the inquiry, but which will not amount to conclusive proof, as was the case in section 41. And with the help of illustration, we came to know that if there was a, it was not based on, so see how it is of a public nature, not of a personal nature. It is not based on a contract, right? Right of way, there may be many reasons for a right of way over the land of another. It may be the reason of necessity. Necessity is something which is of a public nature. It is not based on personal relations, personal contract. So for example, if right of way was given to C on over A's land because of necessity, because there was no alternative way, okay, so for that reason it may happen that that decree may become helpful for B also, because his property may be similarly situated as C. So the case may be similar, the circumstance may be similar, but what section 42 is trying to say, you can bring that judgment will be relevant, but it will not be conclusive. You have to prove each and everything again as well as C did. Okay, this was section 42. Now come to section 43. Judgment, etc., other than those mentioned in section 42 when relevant. Judgment, order, or decree other than those mentioned in section 40, 41, 42, which we have already discussed, are irrelevant. So first, it is providing for a rule that the judgments which were relevant have already been covered under section 40, 41, and 42. And all other judgments, all other category of judgments are irrelevant. Now comes the exception. Unless the existence of judgment, order, or decree is fact in issue or is relevant under some other provision of this act. Okay, the exception is very limited exception. It is saying when the dispute is whether any judgment, decree, or order exists or not. When the question is regarding the existence of a previous judgment, order, or decree, for example, one person is saying that a judgment, decree, or order was given in my favor or in someone else's favor, and the other person is saying no judgment, decree, or order ever came. Such order came as being said by the other party. Only in such cases, when the existence of a previous judgment or order or decree is in question, only then that judgment can be brought on record to show, yes, this judgment, order, or decree exists, and it will become relevant. Otherwise, if a particular case is not falling under section 40, 41, and 42, all other categories of judgment, order, or decrees are irrelevant, and they cannot be brought before the court of law so as to decide a future case according to it. This is very important that you must understand. What? That all other categories of decrees, orders falling outside section 40, 41, and 42 are irrelevant, but the only exception is if the dispute is regarding the existence of that order, judgment, or decree itself, then it can be brought on record to show that it exists. Okay, now come to illustrations. Illustration A and B separately, okay, sue C for a libel which reflects upon each of them. C in each case says that the matter alleged to be libelous is true, and the circumstances are such that it is probably true in each case, and in neither. A obtains a decree against C for damages on the ground that C failed to make out his justification. The fact is irrelevant as against between B and C. So this is A. This illustration A is providing you for a situation where a particular judgment, decree, or order will be irrelevant in another case. What happened in this case? There are two people, A and B. Both of them are suing C, not together, not in the same suit, but in different suit. A is suing independently and B is suing independently, and both of them are suing a same person, that is C. And what are they suing for? The same cause of action, that C has caused libel. Okay, and in both the cases, C take the same defense that the matter which is declared to be libel is of a true nature, which is a defense. But he could not prove it in case with A. Okay, in case between A and C, C could not prove the truthfulness of the statements which are amounting to libel. Then A won the case and he was entitled to damages. Now between B and C, though the nature of the case is same, it is in regard to the same libel, but this judgment is irrelevant for them, because in this case also C will again get the opportunity to prove the truthfulness, and it may happen that in this case he may be successful in proving it. So the other judgment, though it is relating to the same matter, but because it was of personal nature between A and C, is irrelevant for B and C, the case between B and C. Okay, now come to illustration B. A prosecutes B for adultery with C, A's wife. B denies that C is A's wife, but the court convicts B for adultery. Afterwards, C is prosecuted for bigamy in marrying B during A's lifetime. C says that she never was A's wife. The judgment against B is irrelevant as against C. So as far as illustration B is concerned, it is also providing an example when a previous decree or order will be irrelevant for a future case. What happened in this case? There are this person A is prosecuting B. And what is the allegation? That B has committed adultery with C. So who is C? C is A's wife. A and C are husband and wife. And what is the allegation? That B has committed adultery with C. In this case, this B took the justification that C is not married to A. This was the because, and as C was not married to A, I have not committed adultery. But the court reached different conclusion and decided the case against B, and B was prosecuted and punished for adultery. And in the future case, this A person is prosecuting C. What is the basis of the husband is prosecuting his wife? Why he is saying so? He is saying that C has married B, the person who was punished for adultery. She has married B while she was legally wedded with me. She was in a legally valid marriage with me. And as she has married B, another person, she has committed the offense of bigamy. So in this case also, the wife C is taking the defense. No, I am not the wife of A. The same defense which B was saying, taking in the previous case when he was saying that she is not the wife of A. Though the basis of defense in both the cases, in the cases of adultery and in the cases of this wife bigamy, are same. The justification is same. The B was also saying that C is not wife. C is also saying that I am not the wife. Even then, the previous judgment in which it was held that C was actually A's wife and B has committed adultery is not relevant in this case. Again, C will get the opportunity to prove whether she is a legally wedded wife or not. Okay, this is very important. That is the case that previous judgment is completely irrelevant for a future case. Now come to C. A prosecutes B for stealing a cow from him. B is convicted. Okay. A afterwards sues C for the cow which B had sold to him before his conviction. As between A and C, the judgment against B is irrelevant. What is happening in this case, friends? A has prosecuted B. What is the allegation? Allegation is that B stole the cow from A. If there was a cow which belonged to A and B stole it. In that case, B was prosecuted and punished for that stealing. Now, after that, A is now prosecuting C. Who is C? C is the person to whom that cow was sold. Okay, now A is prosecuting C and it's saying that C has brought a cow which was stolen from me and he has dealt in stolen goods. Okay, he was aware that the cow was stolen and he has still bought that. So this is what A is prosecuting C. In this case, between A and C, the judgment which was given in the previous case between A and B, where it was held that B had actually stole that cow, is irrelevant as far as this case is concerned. Why this case is concerned? Because that was between A and B. Now the case is between A and C. Though the main question, main fact and issues are interrelated, because if B stole it, obviously then C can be punished for dealing in stolen goods. But even in that case, in a between case between A and C, A will have to prove each and everything that AC was aware that it was stolen, and after being aware that he bought that cow. Okay, so the previous judgment will not help in the case of A in this case in punishing C. Okay, now come to D. A has obtained a decree for the possession of land against B. C. B's son murders A in consequence. Okay, sorry. A has obtained a decree for the possession of land against B and C. Okay, A has obtained a decree of, so there was a dispute between A on the one side, B and C on the one other side. So there was a case over a particular piece of land. A won that case and got the possession of a particular land. So B's son, one of the parties, B's son was not happy with this and he murdered A, the person who won the case. The existence of the judgment is relevant as showing motive for a crime. A is charged with as showing motive for a crime. Okay. So why this judgment became relevant, friends? Tell me why this judgment became relevant. Existence of the judgment became relevant, previous judgment. Because, friend, murder is an offense against the society. Murder is an offense against the society. So it takes a public nature in itself. That is why the previous judgment is becoming relevant, because what did I say? What did I say? I said when we were dealing with section 42 that if a particular judgment is of a public nature, then that judgment can become relevant. And in this case, as the main issue in the future case is whether B's son has committed murder of A or not. So for proving murder, you have to show the intention also. And this motive is an important part of intention. So this previous judgment is showing the motive of B in killing A. That is why such a previous judgment becomes relevant in this case. Okay. Now come to E. A is charged with theft and with having been previously convicted of theft. The previous conviction is relevant as a fact in issue. So again, friends, what is happening in this case? A is being charged with theft and with having previously convicted of theft, because now he is a offender, continuing offender. He is a proclaimed offender of theft, which is against the society. It is of a public nature. That is why this judgment is becoming relevant. F. A is tried for the murder of B. The fact that B prosecuted A for libel and that A was convicted and sentenced is relevant under section 8 as showing the motive for the fact in issue. Okay. So again, very similar to illustration D. In this case, A is being tried for the murder of B, and the fact is that in the previous occasions there was instances when this person who was murdered, he had made some libelous statements against A. So what this previous judgment is showing? It is showing that A had the motive of killing this person because this person used to make libelous statement against him. So this judgment becomes relevant. Very, very important. Okay. So now come to last section, section 44. fraud or collusion in obtaining judgment or incompetency of the court may be proved. Any party to a suit or other proceeding may show that any judgment, order, or decree which is relevant under section 40, 41, 42, and which has been proved by the adverse party was delivered by a court not competent to deliver it, and or was obtained by fraud or collusion. So friends, so far when we were discussing section 40, when we were discussing section 41, when we were discussing section 42, and even when we were discussing section 43, what we were doing, we were making certain categories of judgments, orders relevant in future cases, right? That was what we were trying to do. Section 44 is saying that even if a particular judgment has become relevant for any of the sections, previous sections, what is the option with the other party? The other party can prove that the judgment which is being relied on was obtained by fraud or by collusion, or the court which granted that judgment or order was incompetent to decide that case. So if the other party against whom that judgment is being brought is able to prove it, the validity of that judgment is gone, right? So section 44 is saying that doesn't matter that it was decided in a previous case, doesn't matter that it is becoming relevant in a future case, but if the party can prove that it was obtained by fraud or collusion, or it was because of the reason of incompetency of court, the importance of that judgment is gone. Okay friends, so this was our discussion from section 40 to section 44, a very important part which talks about relevancy of judgments. Okay, so we will do a quick recap. Section 40 simply provided for those cases when previous judgment were proving that a particular issue has already been decided between the same party. So it was more of in a way enforcing the rule of res judicata in both civil and criminal cases. When we came to section 41, we came to know about the four specific categories of cases, in which category of in those categories of cases the judgments will become relevant in future because of their public nature, because they are against the entire world. What was the four category? Probate jurisdiction, matrimonial, admiralty, and insolvency. And when we came to 42, we came to know about those judgments, though they were not falling under the four categories of 41, they were dealing with matters of public nature, not of private nature, of public nature. But what was the difference? The decrees under 41 were conclusive, but the decrees under 42 were not conclusive proof. But when we came to section 43, we came to know about the general rule that all the cases that are not covered by section 40, 41, and 42, all those judgment in other cases are not relevant in future cases unless and until the existence of that judgment itself is in question. Okay, so then we covered a certain illustration which were a combination. Most of the illustration were emphasizing the fact that if the particular case is of a personal nature, it will not become relevant in future cases. And finally, section 44 clarified that even if a particular judgment is becoming relevant under section 40, 41, 42, it may still be removed if the other party is able to prove that the particular decree was given by fraud or collusion, or the court was suffering from incompetency when the judgment was given. So friends, this was our discussion on relevancy of decisions of the court, judgments of the court in future cases. I hope you understood what I was trying to say. If you have any issues, if you want any clarification, please write down your questions in the comment section. And friends, if you want to appreciate my efforts, please subscribe to my YouTube channel. And if you want to connect with me on Telegram, the invitation link to my Telegram group is in description to the video. Until then, friends, be safe, be happy. I will see you very soon. Bye-bye.